Can y'all hear me? Okay, I'm just going to ask you real quick, guys. Can you hear me? I want to make sure we got our sound on. Anybody throw a quickie up there? Catherine Cooper, you're saying yes, you can hear me? Okay, super. All right. So how's everybody doing? It is Wednesday, February 12th. Yay. Happy hump day. All that good stuff. All right, thanks, guys. I see all those comments. That's great. Okay. I'm just gonna start away here. I know a couple of you were in early. That was really super nice. Mrs. K, you got your questions in first, so there's something to be said about that. I will pop this up. I wanted to ask, if I can't get all my old records, will the SSA honor my new medical records? Well, it depends what you mean by honor them. I was denied reconsideration last month, but my letter says I can qualify for SSDI if I become disabled. I submitted my MRI a month before they make a judgment on my claim. I have many disabilities, but don't know what to do to help win my case. Blessings to you too. Okay, let's just go back to the first one. If I can't get, so the old records, Mrs. K, is what you're going to probably be relying on to prove that the disability started back when. So if you don't have old records, you generally can't prove that your disability started back when because you don't have any records to suggest that they started back then. I have to get this up before it gets really distracting. And they will, of course, honor your new medical records, but the new medical records are about treatment today. It's going to talk about your condition today. It might allude to past surgeries and such, which, you know, usually they're pretty well taken. Like they're not going to disbelieve when a doctor says you had a surgery in 2018 and another one in 2019. Although if you should be able to get those records. They're not so old yet. Although, you know, speaking of records, I know back in the day when things weren't digital, a lot of medical providers and states or medical associations within the states would have kind of it seemed like a 7-year expectation that the doctor's offices would maintain a patient's records for 7 years after the patient stopped treating. Now, a lot of times they didn't want to do that. And I can't tell you back in the day how many times I heard, oh, there was a warehouse fire. So the records are gone. I mean, nobody really believed it, right? Now that it's digital, there is really no reason for a 7-year cutoff. I mean, I suppose they're saying, well, you know, storage costs money, blah, blah, blah. Barely. I mean, hardly. It's not like AI, which takes a lot of energy. The storage, digital storage is tiny, small, and I don't think it takes that much, particularly when they can condense things. But so try to get your old records. And you said you can't get all of them. Maybe you can get some of them, do the best you can. Sometimes it doesn't take every piece because some of the pieces are not going to be relevant. So maybe you have the nooks and crannies there all covered. You sent in your MRI and a month later you were denied. That could mean they didn't look at the MRI, or it could, and the MRI just isn't enough because it's a diagnostic, but maybe the complaints of how it makes you feel, how it limits your functioning are not really expressed in the medical records. That's really important. Speaking to your doctors about the day-to-day problems, and I know that's hard because sometimes they're rushing you out the door, or they spend all of 5 minutes, or you're not sure the medical assistant taking her notes or plugging things in is recording them. I know one way to get around this potentially is some portals want you to pre-register before you even go. I know the big ones around my area, they use Epic and MyChart, and they also have a thing where they email you before your appointment or text you and say, hey, can you go here and pre-register? And that's when you kind of can put in different things. So you might, depending on what your system has, if anything, it could be where you're supposed to put down all your current complaints. Have you had any of these problems? You know, and you might be able to get a little bit in that way. Yes, your letter says you can qualify for SSD if you become disabled. And that's true of anybody. So that's really, they're not telling you anything new. They're saying, we don't think that whatever level looked at your thing, Mrs. K, initial or recom, they're saying we didn't see enough evidence to show you were disabled before your date last insured, or if your date last insured is in the future, up until the present, we haven't seen enough. So you want to either continue treating so you can get more in, particularly for DLI is in the future, or if it's not in the future, that's always a struggle, then you have to get more from the past. And that's just all there is to it. It's a shame when we delay too long in filing for our SSD after we stop working. I don't know what your situation is and your dates, but I would suggest, I mean, if you don't have a representative, I would suggest you get one. By the way, a colleague of mine, she's a non-attorney representative, and I want to say she's in Kentucky. Anyway, Miss Shanna, she was going to come on today, but things got a little hectic at her office, so she's not going to be able to be here. But I told her she could pop in anytime. And we do things differently. She does a lot more in-person, brick and mortar. She has like an office, in town, I believe, because where she lives, I don't know if there's like people are light on internet or what have you, but it's really a demographic, I guess, where there's just going to be more people coming in person versus finding her maybe on the internet. So every practice is different, and she's a newer practitioner relative to myself, so that probably is a good idea when you're first starting out. Okay, hi Angie, good to see you again. When a hearing is requested, does the hearings office obtain updated medical records automatically, or is that the claimant's rep's responsibility, or do they have to ask for assistance? Really good question, because I know the ALJs have a duty, particularly when there's not a rep, to assist a claimant more. I don't have the HALEX or citation for that off the top of my head, but so they generally do that when you don't have a rep. If you do have a rep, they might not. So if you don't have a rep, I would stay in close contact with the OHO, the Office of Hearings Operations, where your judge is at, and confer with them about it. I think you guys still don't have access when you're pro se to your medical file up with the OHO before your hearing, and you have to still get it some other way. Let me know if that's changed yet. I mean, we're hoping that changes, because it doesn't seem fair that only people with attorneys or non-attorney reps can see it. I suppose they think it's a little safer for your stuff, maybe, so that hackers can't get in. I don't know if that's it, maybe. If you are by yourself, I would ask them for assistance, unless you want to get them all yourself. You just need to know what's in there so you know what's missing. You know what I mean? Like if you don't know what they have, how do you know what they don't have? So it is a thing where they're supposed to help you, but I still think you should stay on top of it. If you have an attorney rep, they're supposed to do it as your professional helping you, because it's your burden, but then your representative is kind of picking up some of that burden, right? I don't know that it's expressly no longer the ALJ's responsibility. However, it's just what I practically see. If there's a rep, they're going to expect the representative to do their job, and get all those updates and all that. I'll tell you something. My clients, I'm like the biggest nag. Like, keep me updated. Put it in the message thread every visit. But that's how we stay on top of it. Catherine Cooper, how are you, my dear? Hello, I have a question. What does it mean when they say app is approved, but it's in quality review? How do you determine how they calculate your monthly benefits? Okay, that's a two-pronged question. Quality review is not the same as far as I know, quality review is not the same as non-medical review that everyone seems to get win, lose, or draw. Non-medical review isn't dispositive. Quality review, on the other hand, means a decision has been made and the quality review people have pulled that claim, your claim perhaps, to review it to make sure that the determination is of quality. If it follows the rules and the laws and everything was looked at. I feel like and I thought I read something like about this a year or two ago. I get the sense that awarded ones tend to be pulled for quality review, and to maybe a far lesser extent, denied ones. So if someone's in quality review, I tend to think they may have had a good show with the DDS granted, and it got pulled for quality review. And I think someone in the last month or week or something said that they had quality review and then it was denied. That's never happened in one of my cases. They've been quality reviewed because that's kind of a random thing, but they've never been a return. So I think it's few and far between when they are going to, kick it to the curb and then make you appeal for recon after you've had it. But I guess it does happen. It just doesn't seem to be the most common as far as I know. And that's kind of all anecdotal, right? Oh, sorry, another question. Sorry, Catherine. How do you determine how they calculate monthly benefit? Well, there's calculators on the SSA.gov website, and you could start throwing in your numbers and playing. But before you apply, which is too late for most of you probably, that is when you can go online, get your Social Security earnings statement, and in that, it's going to give you your estimate of what are you able to get SSD as of today, yay or nay. If yay, here are the amounts that we think you would get, our estimate based on what we have. Once you apply, that gets eliminated. They don't want anyone to see estimates of their benefit amount. I'm not sure why, because they could see it the week before. So what's the deal? So I always tell everybody, before you apply, download that mama, at least you have an idea of, as of 2025 or whenever it is, what your estimate is. If you didn't do it before you applied, but you had done it, you had an old, not too old, but somewhat, maybe the year before you had downloaded your earnings statement, that will have it on it. So you can always look at an old one. It's not going to be exact. If anything, it's going to be, well, I shouldn't even say necessarily better, but we'd like to think so. But you can look at an old one and it'll give you some sort of ballpark. All right, Catherine continues. Oh yeah, wanted to add, I got approved at reconsideration. Is that why it went to quality review? So you're approved by the adjudicator, Catherine, and then it was pulled for quality review. So you don't actually have a final approval yet. Unless that actually did come back and you're good to go. But I think it's very promising. So that's great, and congratulations. I'm very happy for you. Salvatore, Emma, hi guys. Good to see you. From New York City. Ooh, I make jokes about New York City sometimes. I hope it doesn't offend you. I am a transplant from New Jersey myself, over to Pennsylvania. So I make fun of myself too. Okay. Taylor. Hi, Taylor. I was reading that you move to 5 to 7 years CDRs at 54 and a half years old. Is this true? Not as far as I know, but if you want to send me the link, I will look at it. There's nothing automated about that. What about a guy that became disabled at 53 due to one of those statutory impairments that gives you a presumed 1 month to recover? I don't think they're going to lay off and say, and he has a sedentary job before, and he's got no cognitive reason why he couldn't do that sedentary job or any other reason. I don't think they're going to give you a 5 to 7. If it was a 2-year CDR, even if he turns 55, because, if he can still do his prior work, he can still, even with grids, if you can do your prior work, you can do your prior work, right? So maybe he couldn't for a year, but then he could. He might have had a closed period. Hope that answers that. So I don't think that's true, but I would love to see the link, Taylor. So if you want to share that to me somehow, that would be super. Okay. Hey, Trish. Okay. Cancer-free. Yay. How are you? Hi, I'm 59 and I have severe COPD and I'm on oxygen 4 liters. I'm so sorry to hear about that. That's got to be a daily struggle. Oxygen 4 liters continuously, and I have severe arthritis and emphysema, and I went through breast cancer in 2014. Now, would it help to call My adjudicator that's on my case. Well, I guess it depends what you're going to tell your adjudicator, but let me see. I see another thing down here from Cancer Free. Continued. I have no income and living with my very abusive son. Oh my goodness. I am so sorry. Who thinks I need a boss, don't they? My 16-year-old thinks I need, he's smarter than me. So, he thinks he should have the final word. But I really need to know who would be able to help me here in 2025. And I have a disability lawyer. Why aren't you talking to your disability lawyer? I mean, they can't help you with your living situation. But if you have questions, Cancer Free, your lawyer is communicating probably as much as necessary and appropriate to your adjudicator. It sounds like you have a strong case, given what you've described. So I would just hang tight. I know it's a little slow right now, last couple of years, and it's going to be a little slow going forward too, with all of the cleanup going on. But just try to hang in there. I know it's got to be a daily struggle for you, and I will be praying for you. Okay, but if you have a rep, I would let the rep do the calling and speak to your rep and see, do you want me to call the adjudicator? They'll probably say no. If you don't have a representative, by all means, call your adjudicator. When you have a case like Cancer Free and an age combined with that, you need to make sure they have all your records. If there's no other way for you to find out, I'd say definitely call. Hi, Terry. Is it Terry Clemens? Is it good that I got a remand telephone hearing? I don't prefer telephone hearings, but ironically, I had a hearing yesterday, and my client had to go on telephone or audio only because her video wasn't working. Yeah, that was unfortunate, but I think it went really well, so that's all good. I was on video and the judge and all that, but I now have a new ALJ on my first remand. Oh, so they sent you back to an ALJ that was not the one that they remanded the decision of. That's unusual. Usually it is a remand to the same judge, guys. People hate that because they're like, he didn't like me, he denied me, and whatever. That's not necessarily true, but usually it goes back to the same ALJ. This time it looks like Terry got a new one. It could be the other ALJ is retiring. It could be ALJ is removed. It could be, I don't know, it could be a variety of things. Could be he passed away. I had one of those. So it could be anything that life might bring upon that take him out of the loop. Usually they're not going to give you a new ALJ just because the other, the first one, the one that denied you. They give him a chance to correct, he or she a chance to, go back and do what they told him to do. And then they get to make a whole new decision, which could be a denial again, or we like to think it's going to be an award. Salvatore, a lot of SSD people be expecting CDRs now that Elon be gone. Oh, I like Elon, is stirring up the SSA. I don't think so. As far as I know, Elon has nothing to do with CDRs. He's actually trying to get monies back, even in the procedures that they're wasting money. Did you guys see him talking yesterday? There was, this is about, not about SSD, but about retirement. When people want to retire from the federal government, it is a very slow process. I know for a fact it's a slow process because I'll have clients who will say, well, I put in for retirement, but they tell me it's going to take 8 or 9 months. I'm like, why? It's not like you have to prove you're disabled. You just want to retire or whatever. And it turns out they have this mine shaft, and I'm not kidding, like literally a physical thing underneath the ground, a whole big thing they built in 1955. And in order to retire, they have to do all this manual paperwork and physically carry it down into the mine shaft where they have these places. It's kind of ridiculous, that it's not. And they said, so the limit on how many people can retire every month depends on how many individual packets the guy that has to walk it down, or guys and girls, have to, lower it down the shaft, so to speak, how fast they can physically do that. So therefore there's limits. That's interesting. But no, yeah, I wouldn't even worry about that. SSD people have always had CDRs. Hasn't changed. Most people, when they keep up with their claim after they prevail, Salvatore, do fine on their CDR if they are still disabled. If they are recovered, like it was a surgery and you just have a certain amount of time to recover from the surgery, and then you're back able to do something. The benefit tends to generally go with the people who are being CDR'd when they're, when they haven't completely stopped treating which gives the optic that you're better. I mean, because if you weren't, why wouldn't you still be going? You have Medicare now, you have all this stuff. There's almost no reason. So yeah, I don't think that's a concern. I think they're going to continue. I think they should continue. Believe me, you don't want people who are not disabled on the ranks of the disabled taking money out of the SSD fund. You don't. We have enough fraud as it is, so we don't want that. Taylor. I got a 1099 from eBay, okay, for selling personal items around the house. Didn't make a profit. Do I need to report this to SS? Didn't want to call if I didn't need to. This is one of those like gray areas, Taylor. Selling personal items is not necessarily work if you're just selling something. Now, if you're on SSI, that's different because then you got to worry about your profit, your net income. But if it's just kind of like investment income, and I don't want to get too in the weeds with this. Unless you were like a professional eBay seller doing it on and on and on and on, or versus I'm just selling something because I'm selling my stuff. That's not really work activity of the kind that would necessarily count. I would be looking at the 1099 amount. You're going to be subtracting cost of goods sold because you're going to be doing a tax return, right? Cost of goods sold is, then if it's going to be considered a business, you got your home office deduction, you got all these other things that are going to drop it down if you so choose to legitimately write off your business expenses if you consider you're selling a business. If you don't, and you just sold stuff online, then I would say that's not from work activity. But that doesn't really answer the question of should I call them? Perhaps not, but get your ducks in a row. So if they ask, you can show, no, I was just selling some stuff, because I don't need it anymore. It's not a business. I wasn't working, and unless you're making, tons of hours and tons of, like if you sell your car and you make $5,000 off it because it was worth, you bought it for 15, you sold it for, I'm sorry, would that even work that way? Yeah, whatever the equity was. I'm doing my math all wrong, but it's kind of a nitpicky thing. But selling your stuff isn't necessarily work. If I sell, and it doesn't mean it's not taxable, but it's not work activity, unless it is. So, kind of have to get in the weeds on that one, Taylor. RO. How to get around doctors not documenting your reports of symptoms and episodes. Oh, yeah. I use my chart, but discovered that doesn't end up in the records. When you say it doesn't end up in the records, was that in your portal records? It doesn't show up? Because I would kind of confirm that. Although you can go into your messages with the doctor, print them all out, put them together, and shoot them up. Like if you shoot your portal records in, attach them, shoot them up, or shoot them up separately if you're sending them to an adjudicator or an ALJ. My understanding is if the SSA, so if your doctor has an arrangement with if your doctor's office, usually it's big health networks, have an arrangement with the SSA for this. The SSA can automatically press a few electric buttons and pull down your entire HITMER file with that health network. And the messages are supposedly in there. I can't confirm that per se, but at my chat with an ALJ I see not too infrequently, we discussed that. And she said, have us do a HITMER because then the messages show up. But when you do portal records, they don't. Unless, of course, like I just said, Ro, if you go in, and I've helped clients do this because some of those messages are really important. Showing those complaints, month after month after month in between visits, or in preparation for a visit, like, doc, I just want to make sure we go over this when I see you next Friday. My back, or I've been in bed for 3 days because of my back, blah, blah, blah. I just got up today. Whatever it is, I think they're so important because sometimes ALJs, if they're prone to deny a particular person, one of the things they will rely on is haven't seen a complaint about that symptom. We saw it once in 2021 and not again. And the person's like, what? That's so wrong, So that is a big problem, poor recording by our medical providers. They're not all as, I don't know, maybe as good as they used to be when they used to handwrite it. But then, of course, you couldn't read the handwriting. So I'm not sure. It's like a catch-22. Yeah, Angie's saying, I think we can ask for the file and they will email it to us as far as the file from the OHA. It's actually OHO, but yes, exactly, they will. They're far more on top of things and your due process rights than the lower levels. The OHO is a whole different animal, is the way I look at it. And they will want to make sure you have your file because I think if you ask for your file and they didn't give it to you well in advance, shortly thereafter, you will probably have a really good grounds for appeal, potentially, if there was stuff missing in there that you could have alleviated, or even arguably just the fact that you couldn't really prepare because you don't know exactly what's in the records and what they said because they didn't send them to you in a timely manner. So the OHO is really good in my experience with getting those. Now we are able to get them online, thank God. But back in the day, it doesn't seem like that long ago, I had to get a CD in the mail also. And it was like, you had to, every CD reader would break and, it was just a big pain in the rear. It's so much better now. But that's if you have a representative, because then they can get it from the ERE, the electric file, whereas you maybe can't if you're unrepresented. SGM, hello. Good to see you. Where legends are made. I was denied and went to QR, quality review. Quality review? Oh, so we were just talking about that. Is that why you put this in here? You're saying you did get a denial, I guess, on initial or recom, and it got pulled for quality review. Took another month before I could file my ALJ appeal. Oh, were you denied and then went to QR, SG, and then they continued the denial? They thought it was okay. Would that be an example of getting a cure on a denial, which, like I was just saying before, I don't really see that? Interesting. Or maybe they do, and I just don't see it, Yeah, another month before I could file my ALJ bill. Well, I hope sometimes, guys, the delay for anything, it can be used to your advantage, particularly if you have weak evidence, which is why you were denied, and you could really bone up on some additional evidence, maybe updated diagnostics. If it's something that would warrant physical therapy, getting that, it can buy you time to do things you may not have been doing. If your lawyer tells you something that would be helpful, potentially, gives you time to do it, all that jazz. Okay, art of practice. Hello. If a claimant has a prior SSDI approved, denied claim, meaning claim that was approved or denied, but is now filing a new claim, okay, at the initial application stage, does DDS have access to the old medical records from the prior claim? Do they have access? I would say they do. Do they always draw them up? Not. I see them do it a lot. Maybe they draw, but I don't see it being all of them. So sometimes I get the impression that it might be cherry picked when they do it. If you have your prior medical records, I would make sure that they're in there, right? Because even if it's if you're using a different onset date now, they won't necessarily be in there. Now, when you did your new claim, if you claim the same old onset date, they're going to reorder those records. So what was before should again be put in the file on that basis alone. So there is that as well. And do they have access? I'm pretty sure they do, because like I said, I've seen them pull up consultative examinations from prior denied applications. It's a little cherry picking. I don't appreciate it. They pull up their denial, like their bad consultative examinations, but not your treating doctor who said the exact same opposite. So there is something about that seems a little untoward, in my opinion, a little conflicted. You're welcome, Catherine. Pain into Passion TV. Ooh. At the federal level, That's an interesting handle you have there, Payne. At the federal level, what does a reversal mean? Oh, a reversal is better, I suppose, than a remand. Although if it's a reversal and remand, I don't know. Sometimes there's I'm trying to think at the federal level. I know at AC, they do, like last flow chart I saw, it was like 15% remands, 84% continued denials, affirming the ALJ, and 1 or 1.5% reversal, which means a complete award decision. Yeah. It might be a reversal. I'm thinking in theory it could be a partially favorable, they award you but at a later date, or they could fully favorably award you with the date you requested, and overturning the ALJ that way at ALC. I believe that might be so above, but I think it's really rare. It's usually a remand. Did you get a reversal and an award? That would be pretty cool because they're not common. Dwayne, nice to see you again. Howdy. How's our favorite Social Security yapper? Keep on yapping. Thank you, Dwayne. I shall. I'm fine. Oh, Gulsaren. Hi from Turkey. Turkey. Nice to see you, Turkey. You're coming long distance. Cancer-free. I just completed my work activity a month ago, and the man who did it with me didn't even know that I'd been on oxygen and sounded surprised. Like it made me think my lawyer also didn't know. Your lawyer may not have reviewed all your records with a fine-tooth comb at this point, because right now it's kind of the gathering stage and they're not preparing for hearing an argument. That's possible. Who's the man who did it with you? Someone in the office, you mean? Like a legal assistant? Keep in mind, like some members of the team in your attorney's office or your rep's office might just do work history reports with people. They might not do the other things. So they would have no real reason to know that you're on oxygen, because their job is to do the work history report, which is 99% about what your prior jobs were about, not about your condition at all. Now with the new, as of June 2024 work history report format, they do say, what about your conditions now? It's down at the bottom of one of the pages, page 1 or page 2. What about your condition now would prevent you from doing this job that you're talking about? So that's where you can really put in your stuff. So I like that question being there. It's good. But that's a newer animal. So Cancer-free, I can't tell you what else to do with your claim. You keep treating, you keep reporting to your lawyers timely when you have a visit. If they don't want that information, which to me would be weird, they'll tell you. So I say, when in doubt, message them every time. I don't know what kind of communication system they have. If they have a portal like we do, and you can just message it in and you don't even have to call or what have you, but keep them apprised. Keep them apprised of every new provider, any new treatment, change in medications, or anything that happens really bad, like, well, that would normally, if it's really bad, normally you'd be going to a provider for it, or the ER or an urgent care, but keep them apprised. Okay. That's the best you can do. And fingers crossed for you. I think you might have it. Okay. As long as you've been treating, I mean, you're getting the prescription for the oxygen. That's pretty huge right there. Jackie, I've been going to therapy for my back and now I'm getting injections. Do that help my claim? Yes, it does. It means you're following some conservative therapies that they're not going to do for you unless they thoroughly believe that you have the pain where they are doing the injections. So sometimes the injections are diagnostic. Sometimes they are purely pain. But either way, it's a step towards just different than it's beyond. Sometimes there's injections and therapy, I suppose. But either one, they're showing that you are doing the real pain in the rear things to help improve your functioning and comfort levels or comfort levels. And it kind of separates those that are unwilling to do that because maybe their pain isn't so bad, but you're willing to do it. So it definitely isn't conclusive by any means, but it's a step in the right direction. And I will say also, therapy, I guess it's physical therapy. I tout this horn a lot. I think physical therapy can be a really great source of objective observations from a professional, not an MD, but someone who's very in tune to their particular specialty, the physical therapist. And they seem to be most of them, very good at documenting how you did that session, your response to their question about how you were since the last session. How did you feel after the last session? So when someone is, really hurting after the prior session, they tend to put that down. They tend to put down limited ROM, range of motion, that occurred during the session, whether there was pain, whether you needed assistance, here and there. So the details can be really intense and ones that you will never find from your orthopedist. You need the orthopedist, and he can refer you for the physical therapy or the neurologist or even the primary care, although I prefer specialists, guys. But a lot of good detail. Think about it. You go twice a week for 8 weeks. That's 16 sessions. How long would it take you to go to your specialist 16 times? Years. And you just banged off a bunch of communication and observations in 16 sessions that are going to be probably well detailed in those records. Physical therapy is my favorite. Okay. All right, Turkey. Gulsaren, I hope I'm saying that right and I'm not butchering it. I was eligible divorce benefits since May 2024. SSA office told me I need a green card. Is that true? Well, I don't know what the divorce benefit. Oh, you mean divorced spouse benefits? Well, you have to be legally present in the country. So I don't know that you need a green card, but you have to be legally present. And if you go back to the country, your citizen country or a different country, you have to check those rules for whether payments can be made there, particularly when it's a dependent benefit. It's a little different than if it was your own benefits. Okay. And there are probably deep reasons for that, but I don't know that a green card is necessarily what is required. I know being legally present is. I'm sure people are trying to get around that, but including some higher ups. But we won't talk about that. Yeah, so it really depends on what you have going on, Gulsaren. I don't know if you're abroad, meaning outside of the United States, then you have to look at those specific rules. I had done last few weeks, a video on non-resident, non-U.S. citizens collecting their, say, retirement or disability that they prevailed on their own work record outside of the country. And for some of them, they have to come back every 6 months for a month. For others, depending on the country they're a citizen of, there's an arrangement with many of the major countries with the USA that's not necessary. So if your country has made that arrangement, a particular agreement, then that doesn't matter. But again, that's for people under their own work record, whereas you are looking for spousal dependent benefits, divorce spouse benefits. So the rules would probably be a little different. So just be sure to look up the different rules, like when you are looking for benefits outside of the country, if that's the case, and your dependent is not your own benefits. Okay. Virginia Gomez. Good afternoon. What does SSA look for in a dire need letter situation for an appeal? Well, there's a few things. There is a page that they provide. I don't have it up in front of me. I can't work because of my health and been filing going on 3 years. Okay, so usually it means I'm going to name some big ones. Terminal illness. Are you going to die in the next 12 months? Do your medical records spell that out? Then you're going to let them know, maybe show them where they can find those records, show them the records. And I hope that's not the case, Virginia. If you are literally going to be homeless, like you're getting foreclosed on as we speak, or you are in the middle of an eviction process as a renter, and have no place to go. You don't have family you can go to. You don't have friends. That that kind of thing. I will tell anecdotally a story. I had a client once who told me she's about to be on the streets. We had been in the case for several months probably, and this is a long time ago. And she said she's going to be homeless. So I said, okay, I will let the OHO know and see if they can expedite your hearing. Stupid me, I was young and naive. She does not, the hearing gets expedited. She is not homeless. She moved in with her boyfriend. The judge inquired about it. The judge spanked her. I learned a good lesson. I will never go on a client's word about something like that. They're going to put it in writing, and they're going to say that, no, there's no place I can go. And of course, the moment she moved in with her boyfriend, if that suddenly, let's say that cropped up, suddenly she didn't expect that to be an option, then you tell that, you notify the SSA or the OHO right away, because now the statement you made before is no longer true. And remember, when we try to get expedition, we are trying to jump ahead of other people that filed before us, whether they filed the appeal before us, or whatever. So, they can't be willy-nilly doing it, because imagine the devastation there. Filing going on 3 years, that is a long time. Were you at initial and recon for a year each, Virginia? What's going on? Why was it taking so long? Or did you not appeal one of them and then have to reapply? You know what I mean? Those things can all make an effect. St. Louis. Yo, good to see you. Please talk about any opportunity to send the ALJ a supplemental brief post-hearing. Is it allowed? Generally, I mean, ideally, you ask the judge during the hearing if you could submit a post-hearing brief to address certain issues that came up during the hearing. They'll usually allow it. Maybe they'll give you a week or two. They're not going to hold it open forever but yeah, that's usually allowed. If you didn't remember to say it at the hearing, I would call them right away after and talk to the assistant or whoever, the clerk, and ask if the judge will give you an extra 2 weeks to send in a post-hearing brief. What is the value of doing it? If there is issues that were unaddressed, maybe something came up, particularly if it's what seemed to be, you got the impression that the judge thinks some impairment has no limitations or very scant, and there's evidence in that file and you want to point it out specifically because it would make a difference to your RFC, perhaps. That might be something. Or if a legal issue cropped up and you want to brief that legal issue and how it relates and what the proper law would be to be applied, that might be one. If the VE brought up something, let's say he said a job could be done under a certain RFC and you happen to have access to DOT information that suggests that that's not true, that was inaccurate, you might want to maybe get something about that. Best practices, do it good, do it concisely, make it a page, don't make it 10, maybe 2 pages. That is conciseness. Don't be blabbering about feelings or things that are not, don't be repeating your testimony at a hearing, unless it's something really, really relevant, but they have your hearing, so they don't need you to transcribe it for them, right? A post-hearing brief are rare for me. I do pre-hearing briefs, so I've already got everything covered. However, that doesn't mean a monkey wrench can't be thrown in on a very rare occasion, and I might ask for a post. I've had it where like a judge would say, counsel, is there any x-ray on with regard to that body part or whatever? I mean, my briefs now actually have all the diagnostics listed in a special attachment, but back then I'd be like, judge, I can do an OCR, but I'd rather not do it during the hearing so we don't waste time. Can I send you that information after the hearing? So I'll do it that way too. But if you're going to do a hearing pre or post, you want it to be maybe 2 pages. I do a little thing where my brief is actually 2 pages and it's just like a paragraph about the theory of my case, some any issues in a little bullet form, and then I bullet out the impairments that are, included but may not be limited to. And that's it for my brief. I attach as an attachment all the medical, like Dr. Jones treatment from blah, blah, blah. And it was about this. And here are the diagnostics, and here are the hospitalizations or surgeries. So, everyone's got their different way of doing briefs. I can't say mine is the best at all. I can't say that. It works well for me. I know some judges have thanked me for them. Others don't give a hoot. But the briefs help me also to make sure I miss nothing for my clients. It's very, very anal. And we actually start it as if we're going to hearing back when we're on initial. So we're getting everything in there because we want to make sure nothing is left out. It's all part of a process to make sure there's nothing left out, because that would be on us, unless the client just never told us about something, which we nag them so much that you almost have no choice, or they get nagged more. So I don't think that's going to happen. St. Louis, have I had good results in doing post hearings? They're so rare. I really can't even say what the results are. I'd like to think, I win almost all my ALJ hearings, so I'd like to think it's a good result. But like I said, they're so rare. I mean, pre-hearings are what I do. So I don't have, any kind of issues that I see, I address them in pre-hearing. That way they're taken care of, Row. I requested formal copy of records and my reports weren't there. Or my reports weren't there, or any notes or visit record. You mean from your provider, Row? So your provider basically said, you haven't treated with us. Well, then I would get them on the phone, right? If you're talking about what you, or are you saying you requested a copy of your SSA file and they weren't there? Well, then you're going to want to call the adjudicator, I think, and say, hey, I noticed you don't have Dr. Jones records. I've been going there for 2 years. Are you having problems getting them? I haven't received any kind of contact from you, but I can certainly reach out to the doctor myself. And that's what I would definitely do. When we have issues, when the SSA is having problems getting them, we'll send out something. We'll actually send out for the claimant's own HIPAA. It has nothing to do with us per se, because that would be that would be contrary to the design of the high-tech HIPAA rights of a patient asking for the patient's records, including the price that the provider can charge him for doing that. So we use that, or it's just the client uses that. Our people will do the faxing and mailing, so our client doesn't have to go through that struggle. I mean, that's one thing we've gotten really fast and quick about. So they don't have to do that logistic. But so if we see that the medical record has not been received by the initial or recon, then I will reach out to the client and be like, it looks like your provider isn't complying with the SSA's request. We're going to pop out one of your HIPAA requests that have them directed to wherever you say to direct them. A particular fax or email. It's going to be all high tech, no paper, but you should reach out and call them as well. And that's kind of how we do it. But if you're self-representing, you've got to kind of do all that on your own. So I definitely suggest being very proactive, because you want those medical records in there, because that is the foundation of your case and required to prevail. Okay. SG, I see you're saying you were denied. So you got a denial, or you had heard from the adjudicator that you were denied and you got a QR at recon. So that doesn't make a lot of sense. Usually the paperwork doesn't go out until the QR is done, but I don't know. But you were approved on OTR. Yay. OTR, guys, on the record review. In the better days, the OHOs usually review a case when they get it, I think, and possibly sometime thereafter, depending on schedules and dockets, I'm sure, and staffing. They will have their people, maybe their attorney advisors or whatever, will be looking at a case that comes in to see if it could be an OTR on the record and no hearing required. If they disagree with the lower level that blatantly. They're not that common. We had one recently. It's always a wonderful thing. I thought my hearing yesterday should have been an OTR, to be honest with you, but it wasn't. So we did hearing, and the hearing went well. As well as I can know, given that we don't have a decision and he didn't tell us on the record. at the hearing if my client prevailed. But anyway, OTRs, gotta love them. Vic, hi, Miss Joy. What was the most time you had to wait to get paid? That is a loaded question. I know that if I don't get my back pay, then you don't get either. I was approved in June of 24 and still no back pay. Oh, you got to get on that. I hope you have a representative. And what's going on with them, Vic? Did they get? I am still waiting about 3 years for one case. I just sent a letter in last month on it just to remind them, like, I haven't been paid here. It doesn't matter that if your stuff says if you're reading something that says I've been paid, I have not. Please go back, look at the banking, see where it went, blah, blah, blah. There was another time that happened, and they had said they actually sent a check to this place in New York City, some loft, some street, it was like a high up floor, like 13th floor. And I'm like, I never go in the city, even though I'm not that far from it. And I am a registered attorney with the SSA, and I have direct deposit with them. So there would never be a mail check. So yeah, sometimes it takes a long time, but June of 2024, no. You need to get on that. I don't know if you've been bumping them, if you have an attorney or a non-attorney rep, they can send the letters. There's not a lot they can do besides the letters. And you can also contact your congressperson, Vic, through their website. Give them a release that they're going to ask for, and something's got to go on with that, because that might have fallen through the cracks. June of 2024, that's way, 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 way too long for you. I mean, it's too long for the representative to get paid too, I would say, but you are the most important person in this equation. So absolutely something has fallen down and it has to get back up. So I would light a match. And I would, if you've been doing that, you've been calling them and they're like, duh, I don't know, meaning the SSA, contact your congressperson. That's what I would be doing. It's a recommendation. And just one of them. Don't contact two at once and have two working on it. That's going to really tick people off and probably confuse things. JW. Hey, y'all. How are you, JW? Oh, Jessica. Here from South Carolina. Hi, Jessica. Nice to see you. And thanks for the shout out. Okay. Deb. Talking to Girl Sarah. Yep. She's trying to help there. Taylor, back to the CDR question. It says under 50 every 3 years age. What says that? What says that? You're going to have to provide a link, Taylor, because that is not a rule necessarily for your case. Every case is different. Yeah. So I wouldn't be listening to just a SSD law firm that recently posted that, although I'd be curious to see. If they posted that, I assume they posted the SSA rules that says that. What they could be saying is, in their experience, their under 50-year-olds have had 3-year diaries, 50 to 59, every 5 to 7 years. That is definitely not SSA rules. I could say that right now because I think I just have an over 50 that has a 3-year CDR. It's a mental health case. Prevailed, but and I had to go all the way to hearing and all that. It was denied twice below, and they were under age 50, and now they're over age 50. And it was an age thing that helped. However, there is not a 5 to 7 year CDR for her. That'd be nice, but no. They might be talking about their own experience. So that to me is very not carved in stone. Yeah. Oh, Taylor, you can't post links, but you can still post the URL, Taylor. That's fine, I think. Just post it, and then it'll be there anyway. I don't know that I will get back to it, but I will try to if I can remember and dig up the time. Hi, Valerie. All right, Gulsaren, let's see. little more details. I have 37 credits. My divorced husband has 40 credits. I'm 67 years old. Yeah, you still don't tell me. Let's see. I'm 67, so old enough. Were you married to him for 10 years? You have to be married for 10 years, first of all, when you're divorced. I assume you were. He's 79 and lives abroad. I have a visa. They told me every 6 months for 1 month. Yeah, well, that makes sense. Look at that video. Again, you're a dependent, so it's going to be different than a person on their own record, I think. You got to look at the dependents. SSA has brochures on that. So if you just ask the Google question under the SSA.gov and then the question, it should come up. Valerie, if you decide you no longer want a rep payee, will Social Security review your case to see if you're better in ways to lose your benefits? Someone else had asked this a few months back. If you won because you were in need of a rep payee, and now you are saying, I've improved enough to not need a rep payee, that is potential. I mean, logically, that does say, you're saying I improved. Unless you were never saying you needed a rep payee before, but they gave you one. And you know, it could be that you can do your own finances because now there's automated bank payments and scheduled payments. People don't have to remember and write out checks and all this stuff. It is much easier to pay one's bills, right? Once we get that set up. In theory, can they look at your case because they think that might mean you've improved? Yeah, I suppose. But if you haven't improved, you know, in a way that means that you could work, you know, that shouldn't really matter. Right? Why did someone need a rep payee? Some people needed a rep payee because they were in a coma in a hospital. Some were not in a coma, but they were in a hospital, you know, for a year doing rehab, maybe building back. And then they're out now, but you know, so much will depend on, on their RFC, their vocational profile, because remember, if you're over 50 and you are now, if it's a physical thing, you are now, physically able to pay your bills when you couldn't before. And I'm not talking about you. I know this is probably not your situation, but even if you are able to pay the bills now, that does not mean you are not relegated. Let's say you're 50, 54. It just shows that you could do sedentary work. You still have that prong met for a grid. Maybe you pass into 55 and now you're even at an easier grid. So it really depends. Usually the rep payee is on a mental health basis though. So I would, I'd be careful. And again, depending on your age, I think it's riskier when you're under 50, right? So that doesn't really answer the question, but it gives you the things you have to kind of think about, risk-wise. Because I think, it could be a sign of improvement. And that's what a CDR is all about, right? Missed H. I have a CalAble. CalAble. Is that like an able bank account? Am I able to make money, deposit it into my regular bank account from Social Security and save it up in the account? I'm not going to be able to discuss your California able account. I'm really not going to have the details of knowledge on that without doing the research first. So unfortunately, I can't say that. If you have an able account, is that because you're on SSI? And you're trying to keep the SSI, money's being deposited into your regular bank account, meaning your SSI payments maybe? Well, you said, from Social Security, but you might have meant SSI. And save it up in a CalAble account. I don't even want to speak to it because if I give the wrong information, that would not be good. And that's not something I feel top of my game about. Missed, I'm really sorry. Since we don't ever have that in our practices, right? We don't, that's not something that's in a viable practice. Unfortunately, I don't really spend a lot of time. I have it on my list of things about the able accounts to get a little bit more details for you guys, but I haven't done it yet. And I don't know exactly when I will, so my apologies. Carl M., my claim is still pending at the adjudication level. I think you mean initial or recon. I have received no calls from my adjudicator. Should I be concerned? Is there even an adjudicator on your case, Carl? I don't know what's going on. If you know who your adjudicator is and you are unrepresented and you're representing yourself, per se, I'd say, why not call your adjudicator? Just say, hey, I'm just trying to find out what's going on. Maybe you don't know who the adjudicator is because you've received no mail. And that could be because you have no adjudicator. If you have a representative, they can get into your e-file. I do this all the time when it's quiet. And I'll see it's only my stuff going in. There's no adjudicator doing anything. So I don't think there's an adjudicator. And then I know. You can, if you have the number to that office, you can just call and ask. And sometimes a different person can give you the information like, oh, yeah, I think you're unassigned right now, or, that kind of thing. So I know it's like being lost in space, right? It's like a big black hole and you don't know where your case is at. We have it all the time. I just have the benefit of being able to see in a little more. I have a case right now that's on remand. I just came in on it after the fella had won the remand and we're heading to hearing, and I could get into the ERA once they connected me, and it's not scheduled yet. And now suddenly I can't get in. I'm like, that's not good. What's going on? So I don't even have the number. I never got a letter from the OHO. So I don't know what that means. I'll have to take a look. I'm going to have to make some phone calls or something, because unless it's just a glitch, and I'll be in there tomorrow. But as of yesterday, I was glitched out. And I asked my client to look at his online access, your own SSA access. And I said, can you see what the status is? What's going on? But anyway, I guess I'll find out. Oh, John gone. Now you stop. Okay. That's embarrassing. This is Roe. Can participating in vocational rehab endanger an approval for SSDI? This has been asked before too. I have never had it be a problem, ever. If the person is under TWP, under SGA, I've never, ever had someone denied on that basis. Now, how much are you participating? Vocational rehab. Are you working full time? Obviously, that's going to be a look-see. Any kind of work is going to be a look-see. And because they want to know, is it under TWP? Is it in TWP? Is it under SGA? Is the work, if it's not in TWP period, what kind of work is it? Are they, as I always say, are you working at a farm throwing bales of hay when you have a bad back, or is it something very genteel? So, it can be looked at, but that doesn't mean anything bad, if it's not bad. I've never seen a person, in my experience, though, can't speak for the other practitioners, who, if my person is going to vocational rehab, we've talked about it. I know how many hours they're doing. I know what they're making. I know what kind of work they're doing. And if I thought it was a problem, I'd have told them, and I always say, if something changes, you have to talk to me first or else you run the risk, right? I was approved 2023 before submitting SSDI app. How were you approved before you even applied? Am I misreading that, Row? VR, vocational rehab, is self-employment track. Since have only earned $650 just last year. I'm going to finish up with Row. Obviously not sustainable income. It's not even, if it's $650 for the year, that's squat. Definitely not SGA. If it's per month, it's still not SGA. In fact, it's not even TWP. So that's good. But vocational rehab approved my business plan to work self-employed and pay for some supplies. Are you doing ticket to work or something? Who suggested I apply for SSDI initially? Oh, that's sweet. SSDI hearing next had 2 denials. Oh, okay. So your medical evidence wasn't strong enough. I hope you've figured out where it was weak. And if you're acting as your own attorney, I think you need to look and make sure where the weaknesses are and strengthen those. It could be you don't have diagnostics showing. I mean, I don't know what your disabilities are, your impairments are, but it's on you to strengthen your case. And that's usually versus treatment, to build that evidence. And then, of course, get that evidence to the judge. I don't think vocational rehab itself, though, is a bar. It's going to be this is all about if you're not earning TWP or SGA, particularly SGA, this is all about they are thinking you have a lacking of sufficient medical evidence. The judge might feel otherwise, or he might feel the same, right? Now's your time to really bolster it, though, while you're waiting for your hearing. So Vic, I don't know what the original question was, Vic, but you've been calling and they keep saying it's in progress. Well, there you go. So it's being worked on. Were you asking for your adjudicator? I forget where you were starting at. What's being worked on? I don't really want to be scrolling up. That's why when there's multiple parts to your question, it makes it a little difficult on here. How much can you earn at 68? This is Diane Monsal. Hi, Diane. How much can you earn at 68 without it affecting your Social Security? $1 million. Yes, unlimited, Diane. Yeehaw. You're not on disability anymore. You're on retirement, and it's full retirement age, so there's no limit. Go for it. That's awesome. Because I'm thinking you're asking because you can work and you want to work. That's great. Okay. Okay, Valerie. When you were approved, there was no rep payee. But a year later, the doctor decided. So your own doctor decided it was in your best interest in having one. I'm just frustrated with my organization. Okay. So your doctor convinced you that you probably need one. I don't know what was going on, Valerie. Were you like overspending? Were you getting taken advantage of and spending money where you needed it for your own bills, stuff like that? Or just being taken advantage of, someone conniving you out of some of your monies? So when you say the doctor, I assume you mean your own treating doctor. And I would tend to trust that person, right? And you're frustrated with your payee organization who controls your monies. I can understand that. I don't really speak to a lot of people about that. Not a lot of people have an organization that does it. Usually people have a friend or family member that's trusted. So I'm wondering if you have someone like that. It's got to be someone you really trust, though. Really reliable person. Or again, I don't know your situation, Valerie. Like, if you're in your late 50s and you want to be your own rep payee and you think you can, or if you can, like I said, if you have a family member or a friend that you trust implicitly, I think if you had one, you would have used one before your organizational rep payee, though, right? So I'm sorry about that, if that's where you're at. Are they not giving you like spending money? Do you know what I mean? Like they're paying your bills, but then they're kind of holding everything back. And if it's SSD, then they can validly keep it in a savings and it's not going to hurt you. But maybe you want to get your hair cut. Maybe you want to get it colored. Maybe you want to do something nice for yourself. Is that where the problem is? That's unfortunate. Ro, I don't think the VR hurts you in and of itself. If your medical records show that you are, and I'm talking about vocational rehab guys, that she was doing before she even applied, if your medical evidence is super strong, which it needs to be to win anyway, the VR, working part-time with or without vocational rehab, will not stop you from winning if it's under SGA, right? So it's all going to boil down to the strength of your medical records, which thus far have not been sufficient, probably. It sounds like you were denied an initial and recon, so that's what you got to work on. But one good thing about your working is even if you're denied because your medical records are not what they want them to be, your working is likely earning you, if you're doing it enough, not $650 a year, but for every, like, so 2025, every $1,810 you earn and pay taxes on this year will be one credit. And those credits, ideally you'd have 4, to really extend out your date last insured so you can keep working. Like, even if you get denied, you can apply again with better evidence the next time for a new bite at the apple for SSD. If you, as long as you're keeping underneath the rules, like under SGA in particular, really careful is under TWP, you can do both and still gain those credits, all 4 for the year after year after year, and still be applying for and or achieving SSD and continue to do that kind of work. Your big thing is the medical evidence. And of course, because you want that DLI to be pushed out in the future, date last insured for your SSD, that's why you want to get those credits. If you're about to lose them, you need to know your date last insured. And for any of you who don't know their date last insured and want to know, this is if you have a pending claim, call 800-772-1213. But they have not been answering the phone for like a year. So that might not be the best way to go. Yeah. Otherwise, you can do the math with your downloaded annual Social Security earnings statement. You can usually figure out what the DLI is through that too, if you know how to do the calculations. Carl. I worked 4 months prior to applying for disability. Will the SSA consider that an unsuccessful work attempt? They may, if you stopped working. If the 4 months are during the period that you claim that you were disabled and you were just trying and attempting to work like a good soldier, yeah, if you asserted your alleged onset date is before that time when you worked, and that's like an intervening time, and you're like, well, they consider it a failed work attempt. Yeah, they can, if it was under SGA, it's not going to matter. If it was full time over SGA, that's what I'd be arguing. If you had to stop that because you were, for whatever reason, not able to perform it, because it was too painful, too limiting, to whatever, or you weren't performing it right and you knew you were going to get canned, so you resigned, or they did can you. It's not bad when they can you in the SSD world, guys. I know it feels like crap when we get canned in the real world outside of SSD, but for our case in the end, that can be a good thing. I always urge people to, if they can get any documentation about the canning being due to performance and not due to laziness or something, but, not performing properly, not keeping pace, maybe it's the attendance. You had to stay home a lot because, you were sick, not well, not able to go to the shift or whatever. Really good paperwork to keep. I know at the time we want to burn it because we're angry, but keep it. Valerie just turned 45, so she's going to leave it alone in terms of the VR. Okay, I understand. I mean, in terms of the RP, representative payee, I understand that. And it's not to say you can't do it successfully. It's just I get it. Michigan, been over 200 days, called SS, and they said still pending and to call back on March 17th if I've heard nothing or see nothing in bank account. Well, I don't know where you started at, Sugar. This is Sugar, who's in Michigan. Nice to see Michigan. What's been over 200 days? Did you already win and you're waiting for a deposit? I don't know where you're at. Oh, John Gone, you're too funny. Bro. Carl M again. Okay, we already did that one. Am I like repeating myself here? M. Williams, good to see you. Do the callback thing. I've had good luck with it. Good afternoon, Ms. Joy. You too. Callback for what? Callback thing. Don't know. Going back to representative payees, guys, if you're not aware, those are when a person is deemed not to be able to handle their own monies. Sometimes an ALJ will recommend one in his decision. And then it usually goes back to the field office and they make the ultimate decision, I believe. In Valerie's case, it looks like they didn't recommend one. It wasn't that, she wasn't having maybe significant problems at the time of that nature where she couldn't handle her own funds, but then maybe something happened. I know that sometimes like a person who is bipolar, manic, depressive, alternating, cycling, they will sometimes have a representative payee. It's often a friend or family member. You can almost pick, as long as they're not extremely, felonious, you can kind of pick. You want it to be someone you can really, really trust, because sometimes getting rid of an RP can be difficult. As Valerie's learned, there's organizational ones. If you don't have, those are companies or people, but they're kind of like approved by the SSA for being a representative payee and handling your monies. And I guess the drawback is they don't know you and they might be less inclined to give you more spending of your money. They're very protective of the corpus and what you need for your bills. But that can be a little over the top. I mean, it's not supposed to necessarily, if you're able to pay your bills or your benefits, maybe it's smart to save a little. I agree with that, but maybe they're being too much, like where you're not able to even go out, for a cup of coffee with a friend or have ice cream in your house. Like they're keeping you on tuna and bread or whatever. I don't know. But that's what that comes down to. And I've seen where it's been recommended and my client is not happy about it. And they ask the SSA then, I don't think I need one because I have all my bills automated through the bank. It works great. I don't need someone controlling my money. I'm not overspending. And the SSA had them, this is not that long ago, in the last year, the SSA field office had the person come in to the field office to kind of discuss it. They wanted to do a look-see. And these clerks are making the decision ultimately. It was the impression I got, whether they recommend it and then enforce an RP. And they didn't. It worked out quite well. I can't speak for any other cases though, because that was just this one. But it was interesting. Oh, yeah. Okay. So M. Williams is saying, when you try to call the 800 number, right? M. Williams, sometimes people get this opportunity. I know I had a person who used to call for me back before they started publishing fax numbers. I needed fax numbers for every case I had. I needed for every field office. So I had a person who would do that little legwork. So I didn't spend time doing that instead of doing legal work with my clients. And they had it where you could opt for a callback. And they would say, it could be because there was a really long wait, so you don't have to sit on hold. Yeah, that's a great option. I don't know that people hear that all the time now, though, Emily, but it looks like you just did. So hopefully they do have that going on. That's a great process, I think, when they're short-staffed, if they use that. And then you just want to make sure that you know to pick up. And I don't even know what the number would be. I don't think it's going to be 800-772-1213, the number you called. And Williams, maybe you can chime in on that. Did the number callback, was it like a 410 number? Was it a Baltimore number? Or what was it? So that people know what to recognize, when the call comes in, so they pick up instead of letting it go to voicemail and then they miss their call. So that's pretty cool. Tiger bite. Let's see. I don't know. I know it's probably been asked, he says, he or she. I just got to this. How long for initial claims in Georgia? I've been waiting 256 days. Yeah, they're long. It's been long for a couple years. It's really, really bad. That's all over the place, not just Georgia. I think sometimes when people go on their online access that they have on their phone or whatever, because sometimes they screenshot it to me, it'll say, you're in so-and-so claim. This normally takes, in the state of so-and-so, this normally takes an estimated so-and-so days. And then you can find out. 256 is a really long time. Do you have an adjudicator? If you do not, maybe it's time to, that means you've received a letter from the adjudicator, which has at least their phone number, and you can call and find out, where you're at. What do you need from me? Do you need me to update my medical? Like blah, blah, blah. Because a lot goes on in 256 days. Your condition can vastly change. Your doctors can change. Your visits, for assuredly, you've been going a gazillion times to the medical providers, right? Your various specialists during the last 256 days. So you really need to let them know. So it's important that you have a way to know if someone's on the case. If they're not, can you still get information up there? Can you send in documents? Ideally, they're ordering your documents, but they're not if there's not an adjudicator. And you kind of want to find that out. If you've been going, you could say, when was the last time I had an adjudicator? Did I get one at all in the last, since I got, out of the field office up to the medical workup office? If they say, no, we're still waiting, maybe you want to contact your congressperson and just say, I've been waiting, it's been 260 days. Go to their website, look for some link. It might be hidden and embedded for help with a federal agency, and start there. They're not going to force the field off the medical workup office to put you in the front of the line, but they're going to do a professional inquiry. And now that office is going to know that congressperson has been inquiring about the slowness on this case. And sometimes it works to light a match. I don't say do this at 30 days or 60 days, because there's people longer than you, and that won't be a really good match. And it's just kind of trying to jump to the front of the line. But 256 days is a very long time. So I kind of think if you don't have an adjudicator, you might be able to get one faster if you contact your congressperson. Okay. Mr. Vincent, howdy. Good to see you again. How is it determined when your disability started by your application or some other way? Thank you. In your application, the information you give provides them with an alleged onset date. What kind of you're alleging you became disabled at? Now, if you said I became unable to work in 2021, but you were working SGA until 2023, they're not going to be able to use that at all, and you can't win back to then. So they will be looking at when the first legal opportunity is. That would be when you stopped working SGA, and then at what point then or thereafter did your medical evidence become sufficient in their eyes to show that you could not work any job in the economy, be it by special rules with the grids or otherwise. Okay. But you can't, even if you have a listing, you're not going to be able to prevail. Even if the medical evidence showed you had the listing back when you were still working, it's not until that you're below SGA that you can do that, because you were still working. Okay. So that's the basics of that, I think. I'm trying to go back up, Sugar. Sugar from Michigan says it's been over 200 days. SSA keeps saying that it's still pending and a callback in March. Blah, blah, blah. And then I'm back down here with Sugar again. She says pending medical since July 2023. All right. So you're on initially. You're at the medical workup office. You're kind of in the same position as pretty much everyone. Initial or recon, it's sitting at the medical office, maybe doesn't have an adjudicator, or if it does, maybe the one just came on and you didn't have one for months. If you're pending medical, that means you're not about to get money in your bank account, because they haven't even made the decision if you're disabled, right, during the time you're insured. So just got to hold on, keep treating, and keep informing them of your treatment, meaning the DDS, not the field office. Virginia, okay, this is about the dire need for an expedited case, right, Virginia? She asked, do you need to have proof of an eviction or electrical notice for dire need? Sure as heck helps. I mean, if you have been the start of eviction, you have the paperwork. So you will want to present that with your request for it to be expedited. Electrical notice, that could help, because if you're about to lose I would argue, it's about losing your shelter and becoming homeless. However, shelter includes, under SSA's various rules for other things, includes your basic utilities. That includes electric, heat, water, garbage, water plumbing, toity. If your electric is about to be shut off, and because you haven't paid it in months, and I don't know if you're north or south. I know the north, I don't even know if they can shut you off. But come warmer months, I bet you they can. I'd use that proof for sure. Yep. If the eviction process has started, the foreclosure process has started, your heat is going to go off. I think that could help, because now if you don't have heat, do you really have a shelter? Because a shelter is supposed to provide heat and running water. Okay. I know it's hard. It's so tough. Okay. Ro, any tips for attending video hearing? We'll have attorney by then. Oh, they just joined the case this month. I would talk to the attorney. Yep. Every case is different. I usually suggest don't go in looking like you're a rock star. I had a client once come to a hearing, and she was in like spandexy workout clothes. She looked adorable. She looked great, fit as a fiddle. That's not really the optic you want to give. If you say let's say it's a mental health problem and you're depressed and in bed most of the time and you don't give a hoot about showering most of the time, I don't suggest you look like all made up and beautiful for your hearing. Flirting, isn't going to work. You know what I mean? Like you want to, don't present yourself as something you are not. If you are a disabled person and let's say you can't wear button-down shirts because your fingers are disabled with arthritis or something, I wouldn't be necessarily putting on a button-down shirt. Yes, it might be that in your function report you explain that your spouse buttons them for you, but I just kind of think you got to wear what you would normally wear on a regular day to keep your body as comfortable as possible, because your body, if it's a physical impairment, is very troubled. And mental health, I'd kind of just present myself as I am, and not try to look. I mean, I know we try to look respectful to a judge and all that, but this is a little different than going to divorce court or criminal court for sure. Here you are presenting your disabled self and trying to persuade somebody that you are not 100%. So you don't really want to look like 200%, right? Ideas how to strengthen proof for an ALJ hearing of medical. Well, your lawyer will probably tell you, treat. If you need updated diagnostics, it's a physical problem, you're going to want to get those. Like if you haven't had an MRI and you have a musculoskeletal problem that is keeping you out of much work, you're going to probably want updated MRIs. All your records have to be updated. Like if you've been going, you want to get all, as close as possible to the hearing as you can. Sometimes it's in pieces, like, all right, you're going to get some now because the hearing could be 3 months away. And then you might try to get those last 3 months. And I know it really depends on how fast providers are, but your lawyer is going to know. There's a 5-day rule too, guys, about evidence. It's generally 5. You have to have all your evidence in, including your brief, 5 business days before your hearing. Mind you, business days. So that means at a minimum, because of weekends, 7 days. If there's a holiday in there, it's going to be 8 days. I roll with the old 10. And don't get me wrong, sometimes I am doing it the last day, but I roll with 10. I actually diary for 30 days in advance. I want to have my brief in by then. So I'm not, lately it hasn't really been working out that way, but my next hearing, I plan on it working out that way. And then your 5-day evidence letter saying, here's the stuff that's outstanding. If you don't have everything in, and you can't because you don't have it, like the provider's been slow and now you're having that deadline of getting that evidence in, you do what's called a 5-day letter, where you tell the judge, I've requested this, and this numerous times. I'm still waiting on these. These are important because, and you say why each one's important. And, done everything within reason to get them. I do think they're going to be coming. Can you leave the hearing open for, however many time you think you'll need, like 2 weeks or sometimes a month, and the judge will or will not. He won't respond back to your letter, but he will bring it up at hearing, or you will bring it up at hearing. If he says, is the record full, and you know you don't have 2 things in, Jones isn't in, and neither is the hospital record when you went to the ER last month, you're going to say, no, judge, and I sent the 5-day letter in, and the so-and-so evidence is still not here. I don't know if you think you need it for a favorable award, judge, or you can award without. Wink, wink. Don't wink. That's just me. But if not, I would appreciate additional time so that has time to get in. And they're very accommodating with that. They're really good because you followed the 5-day rule. If you didn't follow the 5-day rule, they don't have to take any new evidence that comes in after that 5-day deadline. So it's definitely a cover your tuchus kind of thing. Give me a second, guys. Oh, Williams, M. Williams is saying that with regard to making a phone call, it was your local office. Okay, so he's saying when he called his local office and there was going to be a long hold, they have a mechanism where you can ask for a callback. That's great. So it was not the 800 number, but the local office. Do you want a callback number? I don't know if they just can automatically, their system knows what number you're calling from. That's probably it. But that's great. I would use that hands down. I was making those phone calls. What I often do when I'm making a phone call like that, which I try not to have to do too much, I don't even do the callback because I probably won't be there to answer it. So I will sit like the phone and just have it plugged in. I'm going about my work. My phone is here. When that thing rings, I'm right there. If it was going to be that way, but when I'm on, I keep it on hold. So I'm not waiting for a call back because I might miss the call back. I might not hear it, whatever. When I get really wrapped up in stuff, or if I might be on the phone with a client or something like that. So I do tend to wait on hold on the rare occasions I have to do that, but it doesn't interrupt my day at all because I have it right here. I'm going about my work. I got my multiple screens up and I'm continuing to do what I'm going to do, So there is that. Either which way you want it, though, but I think the callback is fabulous. I mean, most people aren't sitting at a desk like I am for 10 hours, so the callback would be helpful for them. Hey, Snacks. Woohoo, good to see you. What does it mean when you put your social in, but someone else's info comes up? That I do not know. Where are you doing that, Snacks? That's crazy. Oh, and Williams, it was a Maryland number. Okay. I always say when I see a 410 number on my phone, given how heavily I'm involved in Social Security, I pick it up. Unless I'm unless I really can't. And then I'm like, hopefully they'll leave a message. That's perfect. I got to, someone's responding back to me about something. It does tend to be a Maryland number. I agree. Donna Anderson. Hi, Donna. Do you think the FRA, full retirement age, is going to be raised? And if so, will that affect those of us already on SSDI as far as grid rules, CDR diaries? Last time such a change was made is 1983. Yes, I know. They changed it from, and I didn't know about it at the time because I was a kid. Well, I was an older kid. But they raised it from 65 to 67. But 67 didn't start in 83. It was like a very graduated thing. In fact, we're still getting to 67 now. When I get there, it'll be 67. But other people right now, it's 66 and change. So that's how long they spread out the change from 65 to 67 back in 1983. It's that gradual. However, do I think I will be very upset if they raise the full retirement age? I don't think that's a good idea because people have a hard time. Our country is so unhealthy. We are. Look, I mean, it's sad enough, there's never going to be a lacking of disability cases. And that means people that are young, under retirement age, are unable to work. And it's really heartbreaking. So the things that are making us sick and unwell, the things outside of like catastrophic accidents, right? And most of my clients are not from catastrophic accidents. It is usually something that I think is probably more environmentally caused, probably food. That's just my opinion. But I think there's so much, I haven't heard anything from this administration about that being a good idea. However, I know there are some speckled, a speck of a person here, a speck of a person there that thinks that might be the way to go. I hope to think that doesn't take on any fuel, because I don't agree with it at all. And they would be doing that obviously to save money, right? So now you would have to go on early retirement and take the discount forever, blah, blah, blah. It's just, now with SSD, Donna, that won't matter. If you're on SSDI, and the grid rules shouldn't matter either. Those stay the same. There's no reason to think they would be altered, since they have nothing to do with the full retirement age. SSDI, you keep that until full retirement age. I mean, obviously, if you improved, yeah, technically there is a chance of a CDR, but I don't know that 2 years would make a difference, or whatever they're going to raise it to. I don't know. I can't imagine they're going to raise it. I would be shocked. I'd be so ticked if Congress did that. I would just, that would be nuts. I think that would be congressional. CDR diaries, well, there is more years left until end of retirement. So yeah, I mean, if you start working too much, yeah, your CDR is going to, kick in when it wouldn't if you had hit a FRA. So in theory, that matters. I don't know in practical senses if that's going to make a difference or not. Doesn't seem like it would. But in theory, yeah, there's more years of SSD, therefore, diaries. Yeah, 1983. All right. I hope that touched on that, Donna. But I don't anyone older that about 40 was affected. Okay. I think you're talking about the age change back in 83. Okay. Carl M. Hi, Stephanie. I've tried to get an attorney at Initial, but they keep informing me to wait for a decision. How old are you, Carl? Tiger Bites. Tiger Bite. I'm a 70%, I think, disabled veteran is what you're saying. I included my award letter as evidence. I am not 100%. So do they even recognize the award letter as significant? They don't. They're going to know that you have recognized disabilities. That's significant. Although your medical records are going to tell that story anyway. So I don't know how major 70 is. They don't actually tell us that. But as you know, and I did a recent video on this, on the legal case that came about, just emphasizing that even though the SSA does not adhere to VA ratings, disability findings, because it's two different programs and two different definitions, they must look at all that evidence. Of course, that is the medical evidence that applies to whatever thing needs medical evidence. So you want to make sure that Tiger Bite, that they have all your VA medical records. Usually they can go in and get them, but sometimes, like I had a client of mine, the VA is very hard to assist my client getting his records. So he uses portal. I saw that the adjudicator hadn't gotten them in like 4 months. So I said, can you go in and get your full medical records from the VA from X date? Say it was October 1st, 2024 to the present, and just upload them to the portal. We have a portal with my clients, so we share things and talk on there and all that business. And then I got them up, just, so the adjudicator had it without, in case the adjudicator was thinking of making a decision on the VA records as they were now without the last 4 months. I didn't want that to happen. So, all right. Snacks. I'm going back to your first question, Snacks. Hi, what does it mean when you put your social in, but someone else's info came up? Okay, that's when I was like, what are you talking about? Oof. Mine has been since 9/9/23, still pending with adjudicator. Okay, that does not answer my question. Sorry. Maryland lights are too high. What are you talking about? Marilyn Wrights? I don't even know. Okay, sorry about that, Snacks. I'm not following. Mr. Vincent, can SSA garnish my SSDI for student loans, and do student loans automatically be forgiven? I believe, yes, they can if it's federally backed, Mr. Vincent. I think you can have a garnishment for that to some degree. And do student loans automatically be forgiven? No. However, if your SSD, let's say you're in a 5 to 7 diary, I think is helpful. You can apply to have your SSD loans automatically forgiven because, and you can do it, I think you can try even with a lesser diary, but you have to really show the discharge people. It's not forgiven, it's discharged, whatever that difference may be. It's not a Biden thing of a forgiven. The discharge has been around forever. If it's found that you're going to be, it seems very evident to be permanently unable to work substantially and therefore pay those loans back, you can prevail on an application for that. So you're going to have to go apply. Okay, it's not going to be automatic. Oh. Zara. Good to see you, Zara. I have court on the 26th and haven't spoken with my attorney. Ever? Do you communicate with the portal, or is that nothing? Maybe give your attorney a call. I assume he's going to do hearing prep with you. That can be an hour to 3 hours. It really depends, on the client's need and if the prep is something they can retain. Of course, if they can't, then it's might be a little useless. But I like to go through what they can expect in terms of the process and the procedure, and then we actually go through the merits of what the judge may ask, and then what I will want to bring out if the judge doesn't ask it and you don't get an opportunity to say it. So if the judge does a direct, then he hands the reins over to me, and then I do some directing of you, and I ask questions that you and I have discussed so we can get those details out that are helpful to your case. We also touch on things that the judge might ask that could be worrisome, and we discuss how to present your position on that, what the situation was, and things that, don't bring up unless they're asked, right? You always have to be honest, but that means in a responsive way to questions asked. It doesn't mean leaving your whole life as a book out there at the hearing. Those are the kind of things we go over. And then a little bit what happened with a vocational expert and all that. And any issues that might crop up, including if it might be possible that we would want to amend our onset date. That's something that we discuss at our prep discussion. We do it by Zoom or by phone. Call your attorney and just say, hey, are we going to, your thing is in, what is it? It's in 2 weeks. Yeah, 2 weeks. Maybe they don't do hearing prep. I don't know. I just think it's nice for people are so anxious to begin with. So at least they'll have a little understanding of how it's going to go, and, the sequence of events, how long it might take, all that kind of thing. Okay. Give them a call. Oh, I'm trying to switch this out. There we go. Kevin, nice to see you. Kevin Varecki. We met before, right, Kevin? Hello from Michigan. Hello. I applied for SSI with lawyers and did everything they asked me to do. So now wait and see. It takes time. And if I'm denied, the lawyer said they will appeal it. Until next time. Okay, very good. And that's all right. So I'm going to harp on that a little bit. Good point. I applied with lawyers and did everything they asked me to do. That is really, really important. They're not going to ask you to do something unless it could strengthen your case. So sometimes things are inconvenient. Maybe go into a specialist you didn't want to bother with, or they can't cure you, so why bother? There's reasons. So I appreciate that you are taking advantage of the lawyer's advice that you're ultimately, if you win, are going to be, that's why you pay them. You know, they know generally what you should be doing to make your case stronger. So when they tell you something, it seems kind of unwise to ignore it. Snacks, I don't know what kind of, yeah, maybe there is fraud going on. You logged in originally, not the ID me. What? Then where'd you log in? He says, it says, this is going back, guys, just a refresher. Snacks says that he logged in with his social and someone else's information popped up. That's crazy. It says, or a derf. All right, that doesn't even seem like a word. Your CD. Oh, order your CD, but 3 different people came up even on my own paperwork. I'm concerned of what website you're at to do that. It comes up John Doe with a social. I don't know. Carl, you're 41. Carl's 41, and the lawyers that he called to try to get assistance said to wait until he's denied. 2 things going on here. I think maybe they just are not willing to accept your case because of your age, maybe, which would depend on your impairments and the evidence of severity and all that stuff. It's a tough age. So if they either maybe don't take that young or they do, but now it depends too. Are they a big factory? Are they a more reasonably sized group that handles every case actually versus, just kind of put it in the chipper? If they're a factory type of place, they might be willing to take your case because they want you to do the work beforehand so they don't have to, and then they just go to the hearing and then hopefully organically you win out. Hopefully they're not one of those kind of outfits. I don't agree with waiting for people to be denied if it's a case I'm going to take. So that would never happen ever. Like if I think it's a case that could be won, if you do X, Y, and Z that I tell you to do, and I put my elbow grease into it, I'm not waiting. If with a vocational profile such as yours at your age, with the age portion of it, those are a category that even people that take younger cases have to have a balance. So it's usually a waiting. It's always full. So they come in, they go out, and then the next one comes in, and it's very difficult. There's not enough, I think, representatives that take them. Not the representatives that actually work in the cases. There could be factories that take them, but I don't know that they actually do workup. So I'm not sure that they actually make a difference in whether you win or lose, but they're going to get the fee if they get on board with you. So I don't know, it's tough, and I don't know your case either, but John Lantieri in the house. Thank you, John. You're the best. Yeah, right? You don't get the records. M. Williams denied SSDI same day. Date last insured expired. Said 207 days for SSI decision. Oh, okay. So you still got a medical. Sounds like, M. Williams, that you still have a medical decision to be made. SSD was denied because from the date that you alleged you were disabled, you weren't even insured for SSDI because you hadn't worked recently enough. So that would explain that while the SSI is still open, but not the SSD. Mac. Hey, Mac. Hey, Steph. If you're getting SSDI and work part-time under SGA, then get a CDR. Could you be sole? I think he's saying chit out of luck. Chit with a CH. Because you are doing daily functions, brushing hair, teeth, etc., and fail? Could you? I don't think brushing your hair and teeth is going to be the reason why you fail. I hope this didn't happen to you. I've never seen someone's brushing their hair and teeth cause them to lose a CDR. Medical records. I cannot emphasize treatment. I have videos, guys. They're a couple years old now. My diagnosis alone isn't going to do it. Treatment, big and small impairments, all those terms. I was on a real rampage when I did those because I was like, come on, you got to. But maybe I need to update those a little bit. But the point remains the same. Your medical evidence is your everything, right? I think we got about 10 minutes left, guys. And remember, I don't know if you heard, I am going to try to be strict with the time ending so that the people that come in at the end can't drag on my day any longer because I got things I got to do. Doug Matthews. Hi, Doug. Michigan in the house again. Okay. I applied September 2nd for a physical disability. I'm 55. They started med review October 2nd. Social Security Disability Determination Examiner started review November 15th. Okay, so it took them 6 weeks to get someone on board. That's not too bad in this day and age. February 10th, I had a mental health eval. Okay, so you're on your way there, Doug. Did you have a question after? Let me scroll down. How much longer do you think until I get a determination? Now that is a loaded question, Doug. You know it. You do have an adjudicator, so it's a very good sign. You're going for an evaluation. Usually that's one of the last steps. Usually it means they've got all the medical records. They only got you the CE because your medical records did not go into the mental health part. Maybe that was poor concentration. Even though you have physical stuff, maybe you're like, and I can't concentrate because of the pain or anxiety that this has put upon me and all that. So, to see where you're at with the focus of concentration, which can definitely affect a grid finding. Grid, you have to have physical, right? But sometimes you need to have some mental too. I don't know your case, so I can't speak to it. But you're probably, when you get the evaluation, unless something untoward happens, usually they then send everything to the medical expert to decide what your RFC is based on all that information that he's getting. Your medical records, the CE, the CE report. And then he will peg you at an RFC. And that RFC is generally going to direct the adjudicator. Even though it's technically the adjudicator's final word, you don't see them really going against what the medical expert says in terms of RFC. Okay. But I think you're on the last leg, unless something untoward happens, like the adjudicator resigns or gets terminated for something bad, or ME goes on vacation. That could drag it out too, right? The ME, there's no ME to review it. They've got their own docket. Moni G, hey, nice to see you again. If I can get your little thing up here. There we go. Hey, if someone else creates a GoFundMe for me, did we talk about this last time, or was that somebody else? Using their own name and account info, using those funds to pay for my bills, will that affect SSDI? No. You can be gifted money one way or the other. SSI, look at it as like which gifts are going to count against SSI. If they're paying your mortgage, problem. If they're paying, I think food is no longer a problem. Double check that new rule. If they are paying your shelter bills, these are very limited. These are the electric, the heat, water, sewer, garbage. Can they pay your vacation? They can. Can they, generally speaking, your cell phone bill? Sure. They can buy you a cell phone. They can pay your bill. They cannot give you the money for you to pay your bill. Okay? Tread carefully there. You got to tread carefully. I mean, you don't want to be looking like you're trying to commit fraud. But again, it's almost like they have their own GoFundMe, and they just want to help you, and they're gifting you. And there's things that can be gifted to an SSI person that doesn't count as income or resources. Let's say your computer broke and you need a new computer. Generally you can have a computer, or you can have a TV. It's personal items. Okay. You are welcome. Oh, thanks, Doug. You're welcome. Yeah, M. Williams, everyone gets the COLA. Okay, Mr. Vincent had asked, Does SSDI also get an increase? Yes, absolutely. There's a lot of applications of COLA. Definitely benefits are one of them. There are some things that COLA doesn't apply to, some of which don't make sense. That's a topic for another day that I think the SSA should have fixed 40 years ago. Okay, Katrina. All right, guys, we got 5 minutes. Hey, why is it taking so long? I was approved for concurrent benefits on January 8th, 2025. Now it's in a view stage 3. If you are approved for concurrent benefits, like a medical thing, there's a few things. It says stage 3. We don't know what that means. Those are internal nonsensical stages. But if you got a medical decision that said we found you disabled when you were insured for SSD as of so-and-so date, and also for SSI, they're going to figure out the SSI numbers and then usually pay that. And then they're going to go back. A different office has to do the SSDI, subtract out the SSI they gave you in any of the same months because you can't get it twice, and then get your back benefits. But January 8th, bless your heart, that's not really that long in this day and age. It really isn't. But it is over a month, so I don't think there's a problem if you call your field office and try to find out what's going on. SSI, did you have your perk yet? Because you said concurrent. That means you won both, SSI and SSD. That means yeah. So they would want a perk, PERC, to determine your financial status for all the months that you're eligible for SSI as being disabled, to make sure you're poor enough for those months. So if you haven't had your perk interview yet, I think that we'll have to, it's Katina. I'm sorry, I said Katrina. They're going to have to figure out your financials if in fact they are going after SSI for you, or to determine if you have SSI, eligibility. They took an SSI claim to begin with, so they were thinking you might, so they did the right thing. Now they have to make sure. Okay. All right. But it's not terribly long yet, but I do think it's been over a month, and it is with SSI. I don't have a problem with calling the SSA field office to find out where it's at. As a claimant, I think you can certainly do that. Fallon, good to see you again. DDS medical experts want me to have x-ray on both of my ankles to see if I am sedentary listing. Well, they probably didn't tell you that, but that's what you're surmising, right? I saw you last week. Yes, I did. I remember. This is what my adjudicator left a voicemail for me before she made decision. Oh, she actually said it to you. That's sweet. I think, yeah, it sounds like she's being diligent, and maybe she thinks that you could be relegated to sedentary, and maybe that is a winning, it's not a sedentary listing. It's a sedentary RFC, exertional aspect of the RFC. She's thinking like, oh, maybe you're at the grid age, Fuang, where sedentary means you win, ding, 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 as long as you can't do your prior job and you can't transfer those skills. So she wants to make sure, it sounds like she might have the other two clinched, and she just has to make sure that you can't do, say, light work, which is on your feet 6 of 8 hours, and that you can only do sedentary. So that sounds promising. Hopefully that will happen soon. Hey, DJ. I mentioned checking my credits. It will not show due to filing according to the SSA website. Oh, your credits. No, you're going to download it to determine your credits. If I'm thinking properly here, what you're saying, you download your earnings statement. It's not going to say your credits, but we can do, you can do the math. I was thinking almost of having a special, probably paid for, prepaid, but not like a regular billable consultation. Maybe something more like a flat fee, like, oh, you want to know what looks like it's going to be your DLI, and all you have, like, you can't get through and you'd rather do it this way. We could look at your earnings statement and go through it and chart it out to see where the credits were earned and where, 10 years runs out. Thinking of doing it. It takes time, though. I'd have to be able to chuck out, probably at least a good half hour each, I'm thinking. And time is so slim right now. So to do it at a very discounted thing is a little difficult because there's a lot of pro bono going on. But we'll see. It's just something we're touting around. You last worked in 2021. I only make $125 a month DJing. Oh yeah, you're the DJ. That's right, DJ. Yeah, that's not even going to earn you credits. So I think we talked about that last week, right? Not going to earn you any credits. It gives you spending money though. So there is that. All right. So now this time, DJ is saying that the attorney says he's at step 3 waiting for analyst. So with this, now you're probably talking about step 3 of the sequential evaluation process. If you guys don't know what the sequential evaluation process is, that is the process used to determine if you are disabled medically by the medical workup office. So versus step 3 coming from the field office, which is nonsensical. Step 3, you have 1 through 5. So there is a video on sequential evaluation process. I think that's right in the title, sequential evaluation process, if you want to learn those steps. And step 3 would be, they're going to determine if you meet a listing. If you don't, what's your RFC? And then they go on to, can you do your prior work? Oh, you cannot? Well, can you do other work? 4 and 5. Oh, Fong, yeah. 56 years old. Yeah, if you're relegated to sedentary, you prevail. Frankly, if you're relegated to light as well, you should be potentially in, unless your HVAC job was considered light. Then the light wouldn't work and you have to be found sedentary, arguably. Okay? Because that would be why you can't do your HVAC, unless there was another reason why you couldn't do your HVAC. That had nothing to do with exertional. DJ tried a job a year ago for 3 weeks, couldn't stay due to back and neck pain. Was it a very physical job? Was it a very sedentary job? What kind of job was it, DJ? I would add that, and guys, this has come up recently where bits and pieces, this is a new case I have of a very young person, like 22 or something like that. I actually represented a parent, and I usually, if it looks viable, I'll take a young person as an exception to our balance. If it's someone's child that I represent, I represented the parent. I try to help, people in the same. If you have a job, let's say you have a job in the spring for 2 months and you make $1,500 a month. Now let's go. Yeah. So that's $3,000. And then you do a month in the summer because that was too much. You had to take off. Then you do a month in summer, make another 1,000. Then you do another month in September, and then you do 2 months, November, December, or whatever. You can, through sporadic, part-time, full-time, whatever, but sporadic work, get your credits. It doesn't have to be. The case I was referring to, DJ, the young person had worked 3 or 4 months at a time, once or twice a year. And with the wages, it was like $20 an hour for unskilled work. It was crazy. It was good for her though, because I think it's going to get her in the ranks of SSD while we fight her case. Now she can't work right now. She's in a hospital, but I think it's going to change the whole, it won't just be SSI we're fighting for. We have this window with SSD, and it's all because that young person, in between having some very terrible issues where completely out of commission in the hospitals, would go to work. And therefore the taxes were paid and the credits. And it is going to be the difference between that young person being on SSI or SSI alone. I don't know if she's going to have so much SSD that the SSI would be gone. I'd like her SSD to be that high, but that I'm not necessarily anticipating. But it could be, mostly SSD and a little bit of SSI. And, if she ever wants to do certain things, if she works again, which she probably will when she recovers a bit, the SSI will disappear and it'll be SSD, and eventually it'll be all SSD because she will have enough credits or a benefit amount as the work continues and starts adding to her benefit amount to put her, in the SSD field. So you could totally do it. Just got to know what you're doing. Get good consult on that. But that 3 weeks, if you earned, I don't know, whatever year it was, you said 2021. I had SSGI up before because I was talking to somebody else about it, their credits earlier today, an old client who's trying to actually get from SSI to SSD. Not my client anymore. We won, but so she's working part-time. And I think at the end of first quarter 2025, she will be SSD aligned and be able to get off the SSI, or at least get the SSD clinched. Might have a little extra with SSI, but if she decides, the SSI will probably be wiped out by her current job. Then it'll be because it'll be like maybe $150 of SSI, the rest SSD, and her work at $600 a month will probably take away the $150, which is fine, because it's still more than what she would have with the SSI, and then she has so much more freedom. But going back to work sporadically is good, even if you feel like a failure. And try to do something more genteel. Go to a temp agency. Like let's say you were doing, well, I'm so used to construction, so I did construction. It only lasted 3 weeks. Well, of course, that's not the job to get when you have a bad back, right? Can't speak to what you're doing, DJ. I don't know. You guys are welcome. I know I got to get off at 3:06. Oh, Kevin, did I butcher this? Is it Varecki? That was the last thing I had to do was the mental evaluation. In other words, I had to see their shrink, but not their doctor because they already have my history from the lawyers. Okay, sounds good. Oh, Justin, good to see you. Late arriver, looks like, or maybe you just weren't talking. Started claim at 49, now 50. Will judge change onset if I get favorable? If he finds that you were disabled at 59, he might not. Or at whatever age that you asserted, if he finds that the medical evidence was strong enough, he'll award you. If he finds that you can't win at that point, under the rules for under 50, but the rule with the 50 makes a difference, then he could suggest you amend your alleged onset date to 50, or he could just find that that's when he finds you disabled at 50. There is no Doge effect on the merits of a case and how they're adjudicating. Doge is about finances and sending monies to unnamed places, including, I heard today, to Social Security funds have actually been sent to unnamed places, so we'll see, and things of that nature. So when people are stealing and defrauding, including government officials, the cleanup's got to happen. Sorry, I'm sticking to that. But it has nothing to do with merits. Not a thing to do with merits. Doge has nothing to do with merits of an SS case. Zippo, no. Zippo. Okay. It all has to do with the bank accounts, guys. Money's being sent abroad for, porno cartoon books or something. I don't know. In Peru. I think that was 32,000. Pretty weird, huh? Doug, I can't give you a time frame. I even forget which ones we were talking about, Doug. If it was that you just had your evaluation, it could be either. Honestly, it really depends. We don't know what they're doing. We don't know who's going on vacation. We don't know how many cases each person has. They're very understaffed. It's been a train wreck for, the last maybe 2. I hope it wasn't 3. I don't know. Well, thank you, Kevin. That's very sweet of you. And I love your eagle. It's amazing. All right. So DJ was standing and sitting in a retail atmosphere record store. Tries to accurate with sitting more. Didn't work out. Okay. So maybe you find, I don't know if you're, there's some jobs you consider stand at will. Maybe that's the type of job to take. You could take it part-time, so we don't even interrupt any current case you have going on. Like 3-hour shifts or whatever you can get of something very genteel. And you do that for, some people do that all year round, and that's not SGA, and it doesn't kill her case. So and they get the credits. So it's, the credits are important, and it also changes your benefit amount for most people. Oh, Mr. Vincent, you're so kind. Yeah, I do have a sense of humor. I'll give myself that. Used to get me in trouble. Yeah. Accommodate. Yeah. Hi, Matthew. I don't understand that question, so I'm going to have to put your SGA. Matthew's asking about, I have problems understanding how my SGA work that ended in January, and I'm having, problems understanding my SGA work that ended in January of 2021 and my non-SGA work that started in November of 22 and ended in August of 24 applies to question 4C and 4E on the third. I don't have the 3368 in front of me, so I can't speak to that. I know that could be confusing because it's like when they say, did you stop working? Well, do you mean SGA or non-SGA? Sometimes I put in, Matthew, and I don't know if it's right or wrong, but it hasn't really hurt me yet with any of my cases. When they ask about work, which one are they talking about? Real work, SGA work, or the non-SGA work? So I'll put in, stopped working for real, January 2021. Then I piddled with non-SGA stuff. I might put January of 2021, and then the remarks in the end say, ever since I stopped working substantially in January 21, I have tried to work. I had tried to work again, but it was all under SGA, and have not even done that since August of 24. They're probably going to want to get an SSA 821 or an 820, depending if it's self-employment or W-2 work. But it's a vague question, so that's how I do it. I say, whenever the last SGA was, boom, and then I explain it. Yeah, but there's been non-SGA work, little dabbles here and there, to be transparent, of course, and to be up, up and up, and not trying to confuse anybody, but their question is confusing. Okay, I think we're good, right, guys? Deb, thanks for all your help out there. Responding to people, that's very helpful. I really appreciate everything, guys. I will probably be here. I anticipate next Wednesday. And remember, if you need an eval for a disability claim, whether you haven't started it yet or thinking of starting it, or yeah, you could be in the middle of it, or you haven't started it yet, or you're thinking about starting it. You can always send an eval. You'll find when you go to joydisability.com, in the upper left, probably of every page, it says the free evaluation. That's for people that are looking for representation or thinking they want to start with representation. That doesn't cost anything. We take a look. If it's something that we can potentially pursue, we let you know, like we'll reach out and let you know. We get a little slow on these sometimes, guys, but let you know. It tells us kind of what category your case would be in, and then we know usually from that eval whether we have openings at all, so we can tell you right away. On the right-hand upper side is if you're looking for education. If you want a consult, you want me to review something. Earlier this week, I had, I did some 821 work with somebody who, was going to be up with an overpayment due to excess work past the trial work period. But, the form had to be done and the person wanted help. So that was my pleasure. It was a prepaid consult. So those things are paid for. So I just want you to know the difference that some are, if the person wants to do it. And the thing that isn't is the evals for representation. So when this law practice is going to represent you, I am personally going to represent you in a claim before the SSA. Okay. Just wanted to be out there because I know some people just think they can email, and I feel like they're let down if no one's spending 3 hours with them teaching them what they need to know, because it's just not doable. This and the 9 o'clock daily video shares are where all the freebie stuff is by and large. Anything else that's like that is the pro bonos for sometimes the homeless. There's a ton of pro bono hours, believe it or not, with almost every single SSD case that we do represent. So there's a lot of unpaid time. So we can't really be giving up more than we already do. So I hope that explains that, guys. But you can always come here and ask questions. So I'm going to try to stick with this midday thing on Wednesdays, 1 o'clock Eastern time, so that people can get some basics. Obviously, it can't be where I review your file. If only I could speed read like that. But some basic questions. All right. And then there's the playlist on the YouTube channel. There's, I don't even know how much. Is it like 800 videos already? Something like that. There's a whole section on function reports. If you're doing your function report, I know that's really stressful. We go, I think I have one coming out, actually, another one about a particular issue with, I think it was number 5. And also there will be a little tidbit for number 6. But there's already videos on those. But when something new comes up about, oh, if this happens to you, this might be good for number 5, I throw those out there too. I hadn't done any function report ones in a while, I don't think. It's just been so busy. But that playlist, I think, can be really useful because it goes question. Each video will be a different question. So it's not like you have to go listen to a whole thing and hear a tidbit about question number 5. All the 5s are going to say it right in the title. Okay. And they're usually short that way too. All right. I will see you guys later. Have a great week. Be safe and take care of each other. Bye.